Going. Good morning, everybody. Welcome to our Zoom webinar for July. Today, we're going to be talking about your agents and who your agents are, which agents you should be picking, why you should be picking them, some considerations you should be thinking about as far as your trustees, your healthcare powers of attorney, your financial powers of attorney, and all those different kinds of people go. So we'll jump right into it. And then once again, if you have questions or whatnot as we're going through this, just type them up into your little chat box thing that you have on your Zoom, and we'll address those questions at the end. Also, we do have a raffle drawing at the end that we're going to do. So we have the gift basket that we do every month. So hopefully you get drawn. So we're going to share my whiteboard here and talk about the agents that you should be thinking about in regards to your different legal documents. And hopefully everybody can see this okay. I'm going to step over here. But when we talk about your agents, there's really the following categories of people that you should be thinking about. Exactly that. Okay. So we have your trustees. That's one category of agent that we need to be thinking about. Who's going to be the trustee of the trust? Okay. Number two is your health care power of attorney agent. Number three is your mental health care power of attorney agent. Number four is your property power of attorney agent. And then number five would be what we call your personal representative on your will. So these are the people that you have to decide who you want to be in charge. In your binder that you have with you, you have all of these documents. You have a trust that has a trustee listed who's going to manage the trust. You have a healthcare power of attorney inside your binder that says these are the people that can make your medical decisions. You should have a mental health care power of attorney that says this is who can make my mental health care decisions. You should have a financial power of attorney or a property power of attorney. And then you should have what's called a pour over will as part of your binder. So these are the different people that are in charge of those different legal documents. And so we often get the question of, well, who should these people be? You know, Dave, I'm having a hard time figuring out who my trustee of my trust should be. Should it be my son, my daughter? Should I pick a bank, a financial institution? What's the criteria I should be looking at in order to decide who the trustees of my trust should be? Well, let's start first with this. What does a trustee do? What responsibilities do they have? And then we can talk about kind of who you should be thinking of in regards to those responsibilities. We have another one to admit. So remember, the trustee of your trust is responsible to administer your trust, to take care of the trust. And the trust was really built to hold title to all of your assets so that if you become incapacitated or die, there's no probate that we have to go through, which means attorney's costs and court costs and delays and all the junk that goes with court. So the person that you pick on the trust to be the trustee, I should back up. Initially, you are the trustee of your trust. So you're the manager of your own trust as long as you're alive and have mental capacity. So you are the initial trustee of your trust. You need to decide who the backup trustee is going to be. We call that person a successor trustee. So they're succeeding you. And who should that person be? Well, number one is thinking about what job that person is going to have, what responsibilities they're going to have, what are they going to have to do if they're serving as your successor trustee. So remember, if the trust owns all of your assets and you become incapacitated, whoever your successor trustee is going to be the person that's managing those assets while you're incapacitated. So that's the person that can make investments and liquidate accounts and open up new accounts and close accounts down and mortgage property and make gifts and do all the things that you were doing as the trustee of your trust. It's just now they're doing it because you're too incapacitated to act as the trustee of your own trust. So you have a successor trustee that steps into your shoes and does those things for you. Also, when you die, when you pass away, your successor trustee is the person that is going to be responsible to inventory all the assets, figure out what it is you own, pay off your final expenses, claims, liens, encumbrances, taxes, and then distribute what's left to your beneficiaries. And so that's their job. That's what a trustee is going to be doing, both while you're incapacitated and when you die. So number one is be thinking about who you trust, right? That's the number one criteria for any one of these things is trust. Who do you trust to carry out your wishes after you've become incapacitated or passed away? A lot of times people will say, well, I don't have an attorney in my family, or I don't have a doctor in my family, or I don't have a CPA in my family. We don't need to be any one of those things, right? You need to have somebody you trust, somebody you know will carry out your wishes if you're incapacitated and or dead. Always remember that whoever you pick as your successor trustee, they can hire professionals. They can hire an attorney to help them do legal work. They can hire a CPA to help them file the tax returns. They can hire a financial advisor to help them with the investments. So the successor trustee doesn't have to be a professional. They just have to be somebody you trust and that you know will hire the right people to help them do their job and take care of things. A lot of times people will say, do they have to live in Arizona? You know, I've got all my kids live in, California, or they're spread throughout the United States. Can I have them still be my trustee even though they don't live here in Arizona? Yes, you can. It has become a little bit more difficult due to COVID. If we have children that live out of state because traveling became harder and banks became more restrictive as far as being able to get into the bank and talk to the bank. And so that became a little bit harder to deal with, but they certainly can live out of state. They do not have to live in Arizona to be your successor trustee. One thing in regards to citizenship, though, you have to be aware of, you cannot have a foreign citizen be a trustee of a United States trust. That will cause income tax issues for the trust that we don't want to incur. So let's say I'm a resident of Arizona. I live here in Arizona, but I'm a citizen of Canada, and all my kids live in Canada. They're Canadian citizens. And I want to have one of my kids be the trustee of my trust if I die or become incapacitated. Well, we can't list your Canadian children as the successor trustees of your trust because that would cause your trust to be what's called a foreign trust, and that would cause income tax issues for the trust, which we don't want to incur. So the only really thing as far as where your kids or successor trustees live, the only exception to that is if they're not US citizens. We can't have them be successor trustees of a US trust. But other than that, they can live pretty much anywhere and they can still be your successor trustee. So with that, trust is number one criteria when you're thinking about who should I pick to be the trustee of my trust. Who do you trust to carry out the responsibilities? Some other things that you should consider are, time. Being a trustee takes a lot of time, right? They're basically, if you're incapacitated, they're taking over your responsibility to pay your bills and take care of all your financial affairs and write checks and do all that kind of stuff. And so, if you've got a son who is the CEO of a Fortune 500 company and he's working 120 hours a week as it is, yeah, you trust him, but is he going to have the time to do what needs to be done if he's listed as your successor trustee and you become incapacitated or die? So time is something to consider. It's certainly not the number one criteria, but it is something to consider. Who has the time to do it, to act as the trustee? I'm trying to think if there's anything else. Like I say, you don't have to be a professional. That the successor trustee can hire people to do those kinds of things, the legal work, the tax work, and all that. But trust, and I would say time would be the next main criteria. Now, let's say you're on the Zoom call today and you're saying, Dave, I don't have anybody that I trust, right? I don't have any kids, and I moved here from Iowa, Illinois, whatever. I don't know anybody here in Arizona. All my friends are my age. I don't want to pick them because they'll probably die before I do, or at the same time, or also be incapacitated with Alzheimer's or whatever. So then who do I pick? Well, if we don't have anybody that we know personally, friend, family member, something like that, then the next category we would go to would be a trusted advisor. Okay, so who's a trusted advisor? Your CPA. You meet with your CPA every year. Maybe you talk to them and see if they would act as a trustee. Maybe you talk to your financial advisor, who you probably meet with every year, see if their firm can act as the successor trustee. Somebody that you have a good relationship with that's been ongoing for a long time, you know them, you trust them, you've been working with them. That'd probably be the next people to go to if you don't have family members or friends that you trust to be the trustee of the trust. If there's nobody in that category, right? We don't have a professional advisor that we trust. We do our taxes with H&R Block. We don't know anybody. We don't have a financial advisor we work with consistently. We just do everything on our own as far as investments go, or something like that. Then who would we pick? Then you're really stuck with the last two categories you can go through, which would be a bank, right? So like Wells Fargo has a trust company that would do it. You've got Northern Trust that does stuff like that. So banks, financial institutions have trust departments that would act as successor trustees. The downside to picking a bank or financial institution is a couple of things. Number one is they're very unflexible, right? So they're going to carry out the terms of the trust exactly as the trust says. There's no wiggle room. And always remember that their main motivation is to make money, right? So they're not charities. They're there to make money. And how do they make money? They make money by managing your assets. So there's a little bit of a conflict there, because sometimes they try to hold on to the money longer than what they otherwise should, because that's how they make their money, is holding on to those investments. The other downside to naming a financial institution like a bank is their fees are a lot more than Uncle Joe or Aunt May. So you can be looking at 1 to 3.5% of the total value of your estate to pay a bank to act as the trustee of your trust. The other thing to consider when it comes to financial institutions is they change their guidelines and their rules all the time in regards to when they will act as a trustee of a trust. Give you a quick example of that. We had a person that came in a few months ago, and what had happened is about 30 years ago, she had created her trust. And at that time, her estate was a certain dollar amount, a lot more than what it is today. And she, at that time, when she created her trust 30 years ago, she went in and she talked to Bank One. At the time, it was Bank One, which is now Chase. And she said, Bank One, will you serve as the trustee on my trust? Well, at that time, they said, what's the size of your estate, total assets? She said, it's this. They said, yes, it fits within our guidelines, we'll do it. And so on her trust, she listed Bank One as the successor trustee of her trust. Well, fast forward in time, and now she's passed away. The size of her estate is a lot less than it was 30 years ago, because she had to pay for some long-term care expenses. And she still has Bank One on the trust document. Well, Bank One's not around anymore. It's, the successor to Bank One is Chase. So Chase is contacted. Chase, look, you're the successor to Bank One. You're listed as the successor trustee on this trust. Well, guess what Chase asks? What's the size of the estate? Well, the size of the estate had dropped. And Chase said, well, we don't serve on trusts that are that small. And so they're not going to take on the responsibility of serving as trustee. Well, there's no successor trustee listed. It was just Bank One. And so now we got to go to court. We got to get the beneficiaries to agree on who the successor trustee would be. That creates this mess. And so you have to constantly stay in touch with the financial institution, your bank, if that's who you've picked as the trustee, and keep them updated on, this is the size of the estate. Have you changed your guidelines on the total dollar amount we have to have in order for you to be the trustee? In a lot of banks, it has to be at least $1 million of investable assets for them to act as the trustee on your trust. Others, it only has to be 500,000, but you want to know that number before you simply list Wells Fargo, Bank of America, Chase as the successor trustee on your trust. And then you want to know every year, have you changed that limit? Have you increased it? Because if you've increased your minimum limit to 3 million and my estate is still only $1 million, you're not going to act as the successor trustee of my trust. And now I'm out of luck if I become incapacitated or die. So those are some issues with naming a bank or financial institution as your successor trustee. Your only other option that you really have, if you have no family or friends that you trust to do it, you don't have a trusted advisor, CPA, financial advisor, something like that you meet with every year. If you don't like the fees and all the stuff that goes with naming a bank or financial institution, then your last option is to name a fiduciary. There's what we call private fiduciaries that serve in that capacity. The issues with naming private fiduciaries, a couple of issues to keep you aware of. Number one is their fees are a lot less than banks. On average, a private fiduciary is going to charge anywhere from $100, $150 an hour to serve, which is a lot less than what a bank would. But the issues you have with private fiduciaries is, number one, most of them are very small. There's, you'll find a private fiduciary company and there's maybe one fiduciary in the company, or maybe two. Well, what happens if they go out of business? What happens if they die? What happens if they get sick? What happens if they get COVID? What happens if they, whatever, their business, they just go out of business, bankruptcy, whatever. Now, whoever you listed as the private fiduciary is out of business, you don't have anybody in there to serve in that capacity. The other issue you have with private fiduciaries, which you have to be very careful with, is you have to research those private fiduciaries. A lot of private fiduciaries have been reprimanded for neglecting to do their duties, breaching fiduciary duties, things like that. There is a website you can go to. We can share that information with you if you want it. That shows every fiduciary and if they've been reprimanded and what they were reprimanded for. And so you can kind of look at that and see as you're doing your research on private fiduciaries if that's the route you're going to go. So that's your options with successor trustees. Hopefully that helps you, give you some guidelines on who you should pick, what responsibilities they're going to have, what's the criteria you should be looking at as far as picking your successor trustee and whatnot. But that's your successor trustee. Next is your healthcare power of attorney. So your healthcare power of attorney is the person that's going to make all your medical decisions for you. So if I get in a car accident and I'm taken to the hospital and I'm in a coma, right? I can't advocate my decisions and what I want with the medical providers, the hospital, the doctors, whoever. Then I have a healthcare power of attorney that steps into my shoes and they're able to tell the doctors what I want to have done. Do the blood transfusion, fix the femur that was broken, those kinds of things. So that's your healthcare power of attorney. And I should have said that with each one of these different categories that you need to have people listed on the document, you want to have at least one primary and at least one backup. Sometimes it's not a bad idea to have a third alternate. So that's just in the event that the first person dies or becomes incapacitated, then you have a backup that's still there to take over that responsibility. Even if you have a bank, right? Let's say number one, you have Wells Fargo listed. And you're like, Wells Fargo will always be there. I don't have to list a backup. Well, remember what happened to the example I just gave you. She listed bank one. Bank one wasn't around, of course, it went to Chase. And then Chase said, we won't do it. So in that case, if Wells Fargo said, we won't serve as the trustee, well, at least we have a backup who you've picked to be in charge. Maybe that's your private fiduciary company that you vetted and you feel comfortable with, and that's your private fiduciary. So always want a primary and at least one backup. Back to healthcare. So healthcare power of attorney, very, very important document to have. One thing a lot of people don't realize, if you're listening to this Zoom call and you have children that are going off to college, right? We have an 18-year-old, a 19-year-old, whatever, that's going off to college. Once they turn 18, you no longer have the legal right to have access to their healthcare information. Prior to them turning 18, you have the right to that information because you're the legal guardian. And once they turn 18, you're no longer the legal guardian. So I've got a kid that goes off to Harvard and gets in a car accident while he's going to a party one night, and he becomes incapacitated. And I call the hospital in Massachusetts and find out, want to know what room number he's in, what condition he's in, who's the doctor on call, who, like all that stuff. They're going to say, Mr. Eastman, who are you, and why would we be releasing this information to you? If I don't have a healthcare power of attorney that says I am his healthcare agent and have access to that information, then they can't release that information to me. And so very important that our kids have healthcare powers of attorney and they've listed us as their agent or something like that. But for you, you also want to have your healthcare power of attorney. You've nominated somebody to make healthcare decisions. What's the criteria for that? Who should you pick? Basically, it's the same as your trust document for your successor trustee. Who do you trust? Who do you think is going to be able to make those hard decisions in regards to your healthcare? And they don't have to be the same person. Sometimes people will say, well, the trustee of the trust is the one that's managing my financial affairs, managing my assets. And so, Uncle Ted is really good at doing that stuff. So we're going to pick Uncle Ted as the successor trustee of the trust. But Uncle Ted has no heart. He's not emotional, right? So we don't want him being our healthcare agent because he'll probably just say, pull the plug. And we don't want that. So maybe we want Aunt Betty to be our healthcare power of attorney. The other thing is, it's probably more important as far as like where they live for this than it is for the trustee of the trust. Because if I'm taken to the hospital and the doctors need to know immediately what procedures to do, what can they do, what can't they do, I probably want somebody that's right here in Arizona that can get to that hospital as quickly as possible. That's the ideal situation. I know some of you on this call say, I don't have any kids that live in Arizona. They're all out of state. Or maybe it's not kids. Maybe it's your brothers or sisters or whatever. They all live out of state. So in the ideal situation, it'd be somebody that lives here that can immediately be there at the hospital and be talking to the doctors and do what needs to be done. But we're not all in that ideal situation. So can you have a kid that lives in California be your healthcare power of attorney? Yes. It's become a lot easier now with being able to do FaceTime on your phone and, texting and overnight mail, and you can jump on a plane now relatively quickly unless COVID is back in place. But those are things that still can be done if you're out of state. So that would be your healthcare power of attorney. And once again, that person is making all of your medical decisions. So they're the ones that are telling the doctors what to do with every type of medical decisions. Do not resuscitate, amputate the limb, dealing with all your medical providers, health insurance, all that kind of stuff. So that's healthcare power of attorney. Mental health care power of attorney, same thing as healthcare. You're going to want a primary and at least one backup, just like on all of these. This person makes your mental health care decisions. So unlike healthcare, in Arizona, we actually differentiate between healthcare and mental health care. So if I suffer from depression, let's say I'm supposed to be taking Prozac every day or every week or whatever. Otherwise, I start locking myself in my bedroom and threatening to commit suicide, and I don't want to come out. Well, in order for my wife or my kids or whoever to commit me to a partial psychiatric hospitalization program so I can get back on my meds and get okay, I have to have a mental health care power of attorney in place that authorizes that person that I picked over here to commit me to a partial psychiatric hospitalization program. Same thing with this, ideally you would pick somebody that lives close by in case they need to act immediately and get me committed, but you may not have that ideal situation. Could we have a California kid do it? Yes. You just have to get on a plane and travel and do stuff that's a little bit more difficult maybe if we live out of state. But that would be your mental health care power of attorney that would take care of mental health care issues. Financial power of attorney. So a lot of people get this confused with the trust. Inside your binder, you have all of these documents. You have a trust, you have healthcare, you have a mental health care, and you have a financial power of attorney, and you have a will. So you have all of these different legal documents that all do different things. the number one confusion is between what does the trust do versus a financial power of attorney. So as long as all your assets are in your trust, right, then it's your trustee of your trust that manages those if you become incapacitated, not a financial power of attorney. A financial power of attorney has no control, no power, no authority over any asset that's in a trust. They only have control over assets that are not in the trust or non-assets. Well, what's a non-asset? A non-asset would be like Cox Cable, my American Express credit card. Those are not assets. So let's say I am in the hospital, I'm in a coma, and there's a bill that comes from Cox Cable, and they're billing me for an extra $300 for something nobody knows what it's for. And my oldest kid wants to know before he writes the check out of the trust, because my checking account's in my trust, let's say, before he writes the check out of the trust checking account, he wants to know, what is that extra $300 for? What am I paying for? So he calls Cox, says, Cox, this is Nixon Eastman. I need to know what the extra $300 for is on this on my dad's bill. Well, Cox is not going to talk to my son because my son is not me. So they're going to say, well, who are you? And why would we talk to you? At which point he's going to say, well, I'm my dad's financial power of attorney. And because I'm his financial power of attorney, you can talk to me. And then they'll say, well, send us a copy of the financial power of attorney, and then we'll talk to you. So that it's not an asset. Cox Cable is not an asset. It's a bill. So it has nothing to do with the trust. And because I'm incapacitated and can't take care of that bill, my financial power of attorney would do that for me. So financial power of attorney only controls two things. Number one is non-trust assets. Something I didn't put in my trust. Let's say I have a car that I didn't put in my trust, and my son wants to sell my car because I'm in a skilled nursing home. I'm never going to drive again. Well, he won't use the trust document to sell the car because it's not in the trust. He'll use my financial power of attorney. Or it's used for non-assets like bills and things like that. So who should be my financial power of attorney? Usually whoever you pick to be the trustee or successor trustee of your trust is also going to be your financial power of attorney, because they're both doing the same thing. They're managing assets either in the trust if it's in the trust, or outside the trust if it's under your financial power of attorney. But they're managing assets. They're taking care of financial responsibilities, either writing checks out of the trust or taking care of that because it's not in the trust. And so we usually have the successor trustee, the financial power of attorney, and the agent, your financial or your personal representative under your will, all the same people, because they're all doing the same thing. They're managing assets, either while I'm alive or incapacitated or when I die. So whoever you picked up here as your successor trustee would also be down here as your financial power of attorney, taking care of that. And then they'd also be on your will as your personal representative. Down here on this personal representative of your will, what is that? What do they do? What's their responsibility? We're hopeful that we're never using what's called your pour over will, because if we're using it, it means two things have happened. Number one is you're dead, and number two is it means you've left assets outside of your trust that you should have put into your trust while you were alive. And because you didn't put the asset in the trust while you're alive, now we have to use your pour over will to open up a probate so that we can gain control of that asset and then distribute it according to the terms of the trust. So once again, hopefully we never use it. If we do have to open probate and use your pour over will to do that, we need to have the will nominate a personal representative. Who do you want to be the one that's going to open probate? Who do you want to be the one that's going to distribute the probate assets into the trust, so then the trustee can distribute it according to the terms of the trust? Well, usually whoever you have as your successor trustee is the personal representative on your will. That person will manage the will, open probate, and do all that. So the same criteria for the trust. Who do we trust? What time do they have? Do they have enough time to take care of all this stuff? those are the number one criteria for the personal representative. So hopefully that helps. Those are all the people inside your binder that you need to pick as far as who's going to do what. This is probably one of the hardest decisions when we're sitting down and filling out the paperwork, when I ask questions on, okay, who's going to be this, who's going to be this, who's going to be this. This is kind of the stumbling block for a lot of people. They're sitting there and say, well, I don't know, who should I pick as the trustee? And you know, my brother, he's good at that, but he's not so good at this and whatnot. So just keep that in mind, that those are kind of things to think about. All right, so questions. Any questions that that you guys have? Looks like we have one here. Where'd it go?
There.
All right, is it proper to have your eldest child be the successor, or is it okay to have the youngest child? I would feel a duty to go in order. How do you handle this with children? All right, good question. So, and I get this a lot, you know, the clients will come in, let's say we have 4 kids. We love all of our kids the same. We want to treat them the same. We don't want to treat them any differently. So the first question people ask is, well, can't I just have all 4 kids together be the trustee, and all 4 kids together be the healthcare, and all 4 kids is the mental, and da 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 da? No, you never want 4 people with equal decision-making power doing everything. That's terrible, terrible planning, causes a tremendous amount of inefficiencies. There's no situation that I can think of on the earth where you have 4 people that have equal authority, equal say, and it runs efficiently. It just doesn't. You know, when we get on a plane to go from here to Florida, we don't have 2 pilots. We have a pilot, we have a co-pilot. Co-pilot doesn't do anything unless the pilot can't act. Right? How to be if both of them could have equal authority, equal say, and one wants to go left and one wants to go right, and then the plane doesn't go anywhere. So you want one captain in charge of the ship at a time. I know you love your kids equally, but there's one captain, and then there's a backup captain, and there's a backup to that, right? So we just have them in order, but we never have them serving together as co. It just causes a lot of inefficiencies. Most of the time we end up in court after you're dead or incapacitated, and we have a judge decide which of the 4 is going to act as the trustee. So pick one at a time, number one. Now, when we have these 4, should we go in order, birth order, right? Should it be our oldest, then just because then that makes sense to the kids and they all feel comfortable. They're like, well, they went in birth order, so that makes sense. Not necessarily. Maybe our oldest child is terrible with money, right? They're terrible with it. Well, do we want them managing our financial affairs just because they're the oldest child? No. Maybe they're super, super compassionate and loving and kind, and they would take care of us healthcare wise. But it's our youngest child. Should we put our oldest child in as our healthcare agent if they're not that type of person, just because they're our oldest? No. So you pick from your kids kind of what they're good at. What are they best at? You know, if our youngest child is really good with finances, they're super, super good with that kind of stuff and manage things well, and they're organized and they have time and whatnot, then there's no reason not to have them as the trustee. You know, and maybe our middle child is a nurse or something. They're in the healthcare profession. Maybe theirs should be our healthcare power of attorney. So no, we don't have to necessarily go in birth order. And I understand it, right? We don't want to hurt kids' feelings. We don't want to make it look like we favor one more than the other. I'll tell you this, I come from a family of 6, and all of my siblings want me to be this on their documents. And I've told every one of them I won't do it. Because I know how much work and time and energy and effort and everything goes into being a trustee. So if your kids knew the amount of time, energy, effort, and work that goes into being a trustee, all of them would say, don't pick me, please. So, you know, I think it's just a matter of helping the kids understand this doesn't show favoritism. If anything, it shows them the kid you hated the most that you picked. That's a joke, but they should not covet being this position, right? This doesn't show favoritism. It doesn't show that you love them more because you picked them as a trustee, nor does it show favoritism because you picked them as your healthcare power of attorney. And I always advocate that we have a conversation with the kids. So there's nothing wrong with, after the documents have been created, sitting down with the kids and saying, okay, Johnny, you've been picked as the trustee, not because we love you the most, that we care about you the most, it's because of these reasons. You live here locally, you're good at finances, this is your world, this is what you do on a daily basis, whatever. And that's why we picked you. And then maybe we picked our daughters to healthcare because of these reasons. And so they kind of understand it, and they get it. But no, the worst thing you can do is just say, well, go in birth order. Now, if everybody, if no one stands out as having more time or a little more experience in regards to these things, they're all equal. It's an equal playing field in that regard. Nobody lives here, everyone's out of state. Then maybe it's, it doesn't really, there's not one is better than the other, then just go in birth order. That's fine. But you don't have to go in birth orders, is my point I'm trying to make. So hopefully that answered that question. I think there were a couple parts to that. I just want to make sure I answered the whole thing. Property eldest child, I would feel a duty to go in order. How do you handle this with children? Okay, so that's how I would handle it. And then if you don't want to have the conversation with your kids while you're alive, certainly the next best thing to do is write a letter that explains, this is why I picked Johnny to be the trustee and Sally to be the healthcare power of attorney. And so it's something in writing from you that explains it to them. And that letter's given to them after you pass away, so they understand why you did what you did. Anyway, so I hope that helped with that question. Any other questions that anybody has? We'll leave it open for just maybe another minute, see if anybody wants to type in another question. But as with, if you're thinking of any questions, just type those in. But as with all this stuff that we talk about, always remember that your documents can be changed, right? Yeah, it does cost money to update documents and change things and tweak things. But the main thing is to make sure that your documents are working like you want them to work. And things change over time, right? So maybe we had Johnny as our successor trustee 20 years ago, but his life has drastically changed. Maybe he's had some health issues. And so now we need to change that and remove him as the trustee and pick Sally as the successor trustee. So it's important that at least every 3 years, that you're looking at your documents, you're reviewing those. We're going through those with you, we're sitting down with you, and we're saying, okay, so 3 years ago when we did this, your successor trustees were these people, your healthcare powers of attorney were these people. Is that who you still want? And have things changed? So we can update stuff based on personal changes that happen in life. So I'd say, like I say, every 3 years, you should be reviewing things, looking at your agents and just saying, is everything still working like we want it to work? With that, we never charge for consultation. So always remember that. There's no fee to come in and sit down and review it and talk about it and ask questions. We never charge for those things. The only time we charge a fee is if we have to amend these documents. If we have to make a change to these documents, then yes, we charge a fee to make a change to the document. But if you come in and you say, hey, Dave, everything's working like I still want it to work, I just wanted to verify that these are the people that are in charge, then there's never a fee for that stuff. So feel free to come in anytime and have that reviewed and looked at. So any other questions on our agents, who we should pick and how it works? Doesn't look like we've had any more questions come in. So what we're going to do now is we're going to do a raffle drawing for our gift basket. I know that some of you that are on our Zoom call today have already received some of our gift baskets. You are entitled to receive one every month if your name is the lucky name that gets drawn. So we don't take your name out because you've already won. And I think those of you that have won the gift basket, you can attest to the fact that they're pretty nice gift baskets. Lisa does a great job of picking those out and getting those. So we're going to have Elisa draw a name out of the cup here. Where do we get? Dan and Diane Lowry. So that's whose name we drew out. Mr. and Ms. Lowry, if you want to call into the office, find a time for you to come in, pick up your gift basket, and get that to you. So if there's no other questions, we're going to end our Zoom call today. And then I think we have one already set up for August.
And Wednesday, I'm not sure what that is.
Do we know the topic? If not, it's okay. We'll send out an email with the topic, but like I say, I love doing these. We used to do these in person before COVID, and we'll continue to do these. Oh, it looks like Mr. Lowry is willing to. He already won, so he said put it in the hopper and do another drawing. Well, that's very kind of you, Mr. Lowry. So we have Lee K. So Lee K, we'll be reaching out, or reach out to us. We'll find a way to get that gift basket to you. So once again, thanks everybody. Appreciate you. We'll have this again next month. Stay safe, and we'll see you next month. Thanks. Bye.